Hi everyone, and welcome to today's webinar. Ciphr is presenting an employment law update with our friends at Shoosmiths. It's great to have so many of you with us today. I'm Catherine, I'm Ciphr's head of content, and I've got lots of friendly faces on the call with me today. Joining me is my Ciphr colleague Jackie, and she's one of our account development managers, and she'll be giving a little overview of Ciphr solutions before we dive into the employment law. So welcome Jackie, thanks for joining us.
Hi everyone, thanks for joining, and really looking forward to the next hour or so.
And then from Shoosmiths, we've got Stuart, Charlotte and Antonia. They're our trio of employment law experts. Stuart, great to have you back with us. Some of people on the call might have joined our October employment webinar with you, so it's great to have you back once again.
Yeah, on behalf of me and the rest of the Shoosmiths team, thanks so much for inviting us back. Delighted to be here, and I hope there is something for everybody on the call to take away.
Many on the call today joining may already have an existing HR system. Maybe it's something you may consider in the future. But Ciphr's platform, it helps organisations to manage their end-to-end employee life cycle so that you can deliver amazing experiences for your employees. Ciphr helps all of our organisations to be confident that they can access their people data in one place, make sure it's secure, most definitely create time savings and efficiencies, and I'll talk a little bit more about our API connections to not only our own solutions but also third-party tools. Thank you. Just the next one, Catherine. So just to expand a little bit on the API, this is a push and pull at rest API integration. So this will make sure that data is moving not only across all of our own solutions, which include HR, payroll, learning management and training solutions, but also it integrates to third-party platforms. And so far to date, we've got over 150 integrations across 50 different business systems, and that list just keeps on growing. So today we just wanted to focus really about challenges. So for those of you that are currently using a HR system, lots of organisations have outgrown the HR and payroll systems, and they may be experiencing labour intensive processes, struggle with insights to people and performance, and looking at ways that they can improve. Challenges often that we discuss in the early days with anyone looking at HR systems is lack of employee engagement, getting their employees to use the system, unable to trust the information, that it's not always accurate and up to date. There's lots of duplication that when we first meet customers, they complain about things, processes still being very labour intensive, and also having to maintain multiple systems, which again comes back to data not always being accurate. Next one. So how do you get the right system? Lots of things to consider when you embark on considering investing in a system. So you need to consider how it's going to streamline your work, not getting you in your way. Reports need to be easy to compile and make sure that they're accurate. You should always be able to configure automation. So instead of doing things manually, you need to create those automatic notifications, those automatic reminders, such as holidays, how much holidays somebody's got left, when managers need to maybe carry out an appraisal. And it's really important, more so now, that your HR and your payroll will integrate. So it's all about making sure that your staff are paid on time, they're paid accurately, and making sure that that HR data change transitions nice and smoothly over into your payroll. So by building the right processes into your system, it means managers and employees can take responsibility for managing their own data. It can make payrolls quicker, it can make HR data more accurate, and most importantly, it can free the HR team up to make more of those strategic and organisational decisions. So it's important that your HR system is intuitive, it's important that you get buy-in from all of your community and everybody wants to use it. So the right HR system, we can include onboarding, so it's critical that you get the right staff, that you onboard them in the right way, that you're going to get them being productive as quickly as possible, and most importantly, that you'll retain the right staff. So integration with third-party providers, again, helps with that journey. And we can even do clever things like create that identity and background checks right from that recruitment process as well. Next one, Catherine. So I've just put a snapshot of customers. We've got a huge diverse range of customers. So we've got over 600 customers using Ciphr solutions. That's globally, and they range from public sector, private sector, not-for-profit. One of our key clients who have also helped us develop the system is the Information Commissioner's Office, who you can see in the centre there. We've got organisations like the Natural History Museum, the Met Office, and one of our most recent acquisitions who have noticed a notable change is Marshalls, who've just embarked on a programme of implementing the Ciphr learning management solution. So last slide, Catherine. So in terms, if you want to know more about Ciphr and you want to know more about why Ciphr customers love using our systems, we've popped up on screen there, our website, but please feel free to raise any queries or pop onto the website. Thank you.
Thanks so much, Jackie, for that quick look at Ciphr solutions. If you do want any more information, at the end of this broadcast, it's going to be a survey where you can just tick a box and one of our team members will get back to you. I should mention, of course, this is all being recorded, so if you want to revisit any information at any time, we can absolutely do that. We will send out the recording to you after this broadcast. Who's going to take it away for me?
Fantastic, Catherine, it's me. Thank you, Jackie. Good morning again, everybody. On behalf of Charlotte, Antonia and I, we are absolutely delighted to be delivering our second employment law webinar for Ciphr this morning. By way of brief introduction, my name is Stuart Lawrence and I'm a partner here at Shoosmiths. I'm joined by Charlotte Staples, who's one of our fab senior associates based at our Nottingham office, who leads on everything that we do with regards to online training for clients, and our absolutely brilliant professional supports lawyer, Antonia Blackwell, who is going to be helping wade through your questions that you've got the ability to ask. Now, we've got nearly, looking at the numbers, over 400 people online at the moment. Unfortunately, we're unable to have you all on audio, but I think it's already been mentioned, you've got the ability to raise questions through the chat function. Please do that. We'll either pick them up as we go along. Alternatively, we'll try and build in some time for some questions at the end. But yeah, no, the seminar this morning is going to follow the same sort of format as last year. Thanks for all the feedback in relation to the autumn seminar. We're glad it landed well, but you'll see there's some familiarity in relation to what we're going to cover. So in relation to what we're going to cover, next slide please, Catherine. Let's have a quick overview of what we're going to deal with. We're going to kick off with a really quick legislation update. It is actually going to be incredibly brief on the basis that not much has happened for once in 6 months from a legislation perspective. Then we're going to give you an update in relation to what's on the horizon. So all those things that is looks like it's coming down the track, so that you've got an idea of what you need to prepare for. And then we're going to finish off by looking at some of the most recent important cases that have been reported since last October. We've due to finish about 12:15. I'm an absolute stickler when it comes to timing, so I'll make sure that we're done and we don't overrun. So if we can skip through a couple of slides, then we're going to kick off with the legislation update. I'm sticking with that. And I'm going to kick off with a topic I believe may have been covered briefly on one of your Ciphr's other webinars, but it is a subject that is particularly close to my heart, and that is the updates in relation to national minimum wage. When we delivered the first webinar, I mentioned the fact that I'd advised at that time on 3 national minimum wage investigations. I've now been instructed in relation to 4 national minimum wage investigations. They're incredibly complex, time consuming, and the liabilities for companies if they get it wrong can be absolutely vast. So the slides set out the new rates of pay that were effective from the 1st of April 2023. So all national minimum wage rates have been increased by 9.7%. It's the largest increase since the national living wage was introduced in 2016, and that simply reflects inflationary pressures and cost of living. So they should all have been implemented by now. So depending on, to the extent that you pay individuals either close or just above national minimum wage, all these pay rates should now be in place. So depending upon how often you pay your employees, they should already have started to feel the benefit of these, or if you're paying on a monthly basis, they'll get their first new increased pay packet at the end of April. The other point to flag, as I flagged last time, is the fact that these rates, you need to always ensure that these are paid above, or you comply with national minimum wage, less any points that need to be deducted. So things like salary sacrifice, cost of uniforms and alike, they all need to be taken into account. So you need to make sure that you're paying these and that your national minimum wage is net of those deductions. And the slide also includes the amount that can be offset by way of accommodation offset. Next slide, please, by way of legislation update, is the increase in relation to statutory rates of pay. And this changed slightly different date. I've got no idea as to why there's a slightly different change as far as the dates are concerned, but these were all effective from the 10th of April. So the slide sets out the increases to statutory sick pay, maternity pay and alike, and the maximum weeks pay that are relevant for things like calculating statutory redundancy pay and the basic award to the extent that you're facing a claim of unfair dismissal. What's also increased is the maximum compensatory award for ordinary unfair dismissal. I've been doing this job long enough that I can remember when that figure was a lot lower, and it seems to me, I don't know about Antonia and Charlotte, but it seems to me that that figure seems to be increasing even quicker than inflation, and there's not many things that are increasing quicker than inflation. So the maximum compensatory award is the lower of either the 105,707 figure or a year's salary. And what's not on the slide, which is also of interest, is the fact that the bands for discrimination awards, the Vento guideline bands, have been increased as well. It's very rare nowadays for Charlotte or I or any of the national team here to face straightforward claims of unfair dismissal. Usually there is some element of discrimination, and again they have increased significantly over the years. It only feels like yesterday that the first band was between £500 and £5,000, but believe it or not, if you're facing a discrimination claim, the lowest band, so the lower band, so for the one-off acts of discrimination or the least offensive forms of discrimination, the lowest band award of compensation is between £1,100 and £11,200. Middle band is now between £11,200 and £33,700, and the upper band is between £33,700 and £56,200. That's not the maximum. In exceptional cases, you can go beyond that, but they are the new bands. That's it for legislation update. I told you it was brief. We're now going to move on to what's on the horizon. So as I say, this is the section of this morning where we are going to basically give you an update as to what's coming down the track. Some of these we touched on briefly in October last year, and so therefore some of what we're going to cover relates to just basically updates as to how things have moved on from there. I'm going to give an update briefly in relation to where we are in relation to carers leave and enhanced rights for pregnant employees and new mothers, and then Charlotte's going to cover some potential changes in relation to flexible working. And at that point I'd just probably pause and say it's probably one of those areas, flexible working, where we are seeing not only an increase, was one of those areas where we're getting a spike of queries from clients, but it's always been a difficult area to advise on, dealing with flexible working requests. But our view is that it's becoming increasingly difficult to deal with flexible working requests. And if we've got time, we might share our views in relation to that later. Charlotte's then going to deal with the other points on those slides. So for me, carers leave, what do I want to say about that? Well, I suppose the position in relation to carers leave is that, and I suppose carers generally, is that this is one of those topics that has received a lot of press attention. I suppose the general position is that the position in relation to carers is that they are quite an unsupported group, whether or not that's generally, but also in the context of any rights that relate to their employment and their relationship with their employer. But what it looks like is that it won't be long before employees providing or arranging care will have an entitlement to 1 week's unpaid leave. This started live, just so that you can understand where we're at from a timings perspective. It had its first reading, it was a private members bill, it had its first reading back in June 2022, and the second reading actually took place pretty much on the same day as we delivered the last Ciphr webinar. The right, if it is introduced, and we think it's pretty likely that it will be introduced, will enable carers to basically have 1 week's unpaid leave. It's going to be a day one right. There is going to be no qualified service, and it's expected that it's going to have a significant impact on employers up and down the country. Why? Well, according to statistics, believe it or not, there are 2 million working employees out there, or workers out there, who the statistics show provide care. So there's potentially 2 million employees and workers who will potentially have this entitlement to an extra day off, every day off, an extra week off a year. And currently carers don't have any statutory entitlement to take leave, so therefore they have to look to either take normal leave or any other form of statutory leave in order to take time off to assist with their caring responsibilities. What it appears is that it's going to be quite a relaxed piece of legislation, so carers are not going to need to provide any evidence of how the leave is going to be taken or how it's going to be used. And I think the intention behind that is to simplify things both from an employer perspective and an employee perspective. Employees who take this leave are going to have the same rights of protection in relation to employees who take leave for any of the other statutory reasons. So they're going to be protected in relation to not suffering a detriment or from being dismissed as a result of exercising this right. The only eligibility requirement is that employees are going to have to be able to show a relationship between them and the person that they're caring for. And it's expected that relationship is going to mirror what's currently in place in relation to dependent care leave. And it's currently proposed that when taking that leave, carers will be able to take that off either in half days, in single days, or as a full week block. And the only other thing that I'd say, having read around the subject, is that the only other commentary I've seen is that whether or not actually the provision of 1 week is actually sufficient, and query whether or not actually we're going to end up with carers having a greater entitlement, possibly up to 2 weeks leave. But that very much looks like that's coming into force. Haven't got an exact date yet, but I expect that may well be. Certainly, I'd be surprised if it's not introduced by the end of next year. Okay, moving on to the extension of redundancy protection, and this is another one that's received an awful lot of press attention. And it relates to the possible extension afforded to pregnant women and new parents returning from maternity, adoption, shared parental leave, where a redundancy situation arises. Now, I'm sure everybody on the call will be aware today that there are an awful lot of protections for women whose role is identified as redundant whilst they're off on maternity leave. For the purposes of today's webinar, what I'm not going to do is I'm not going to go into every single right, nor am I going to provide advice about what process you should follow should there be a redundancy situation when someone is off. But what I want to do is I want to drill down on one particular current right and explain how that it's being proposed that is going to be changed. So as I'm sure most of you are aware, probably in the context of a redundancy situation, the key last stage of any redundancy process is to ensure that if you're going to dismiss them fairly, that you comply with your duties with regards to considering an at-risk employee of redundancy in relation to suitable alternative employment. When the redundancy proposal impacts a woman on maternity leave, where a suitable alternative vacancy arises, she must be offered it. She's got really enhanced protections. There's no need for her to apply to it. She goes to the front of the queue, and this is one of those rare occasions of positive discrimination. We see that pretty infrequently in the world of employment law. But the brutal reality of this, and this applies during what's called the protected period, is that, and just to make sure that everyone's got an understanding as to what Charlotte and I and the rest of the Shoosmiths employment team do. Here at Shoosmiths, we do 90% of our work for employers and 10% for senior execs. But the brutal reality of this right is that it means that an awful lot of employers will put off redundancy processes until the employee has returned from maternity leave, so that the employee is outside of the protected period, and then the employee doesn't have those enhanced protections. And so what that often means is that, unfortunately, individuals come back from maternity leave and then they face a redundancy situation that then results in their redundancy situation. Don't just take mine and Charlotte's and the rest of the Shoosmiths employment team's word for it. The Equality and Human Rights Commission conducted a poll, and they've suggested that as many as, and this is a really shocking figure, 54,000 women a year are pushed out of work having become pregnant, and a lot of those arise from redundancy situations when they return. So in October last year, the government announced that it was backing a private members bill to basically extend the protections to women in the context of a redundancy situation beyond the current protected period, so that what the protection is now going to last for is either 18 months from the point of birth or from the point that they return to work, depending upon the type of leave that's been taken. Again, this is in relatively advanced stages. It's passed through its readings at the House of Commons. It's now at the House of Lords. And again, the expectation is that this will come in some shape or form in the not too distant future. It's not in the books at the moment, but the only other thing in talking about this subject is to highlight one really useful reference point, given that there is quite a lot of commentary about there being a large number of redundancies later on in 2023, early 2024, depending on whatever happens with the economy. But there is an ACAS guide out there dedicated to managing redundancies for pregnant employees or those on maternity leave, and I'd very much point you in the direction of that to the extent that you need assistance with dealing with the redundancy with somebody who's off on maternity leave. Okay, that's enough for me for my opening. Back to Charlotte.
Thanks, Stuart, and good morning, everybody. So carrying on with the what's on the horizon, the next topic we're looking at is the Flexible Working Bill. Now, this has very much come about following the post-pandemic era and many businesses operating so successfully at home for such a long period of time. So this bill is currently in the House of Lords, and just if you're not sure about the process, going through Parliament, it starts off in the House of Commons, goes to the House of Lords, goes back to the House of Commons, and then potentially receives royal assent if everybody agrees down that process. So we're at the second stage now. This is in the House of Lords. There could therefore be a few changes that are applied, but the basic things that we think are likely to go ahead when this comes into effect are that flexible working will become a day one right. You don't need any minimum period of service, or you won't need any minimum period of service to request it. And you will have the ability to make 2 statutory requests in any 12-month period, whereas at the moment it's just 1. Now, there's still going to be the same statutory grounds on which a business can refuse a flexible working request. But, and this comes with a really big but, as Stuart says, flexible working is becoming a very tricky area. And that's because so many businesses, as we've said, have operated very successfully at home. Many office workers particularly are set up to work from home, computers, laptops, phones, etc. And to turn down a flexible working request, you've got to have a legitimate reason why it's not going to work at home. And if it has already worked and been working for a very, very long period of time, then a business is going to find it very, very difficult to turn down. So the other change in this is that employers are going to be required to consult with employees before rejecting any requests. That elevates the level of discussions that has to take place from at the moment. Whereas at the moment there has to be a meeting, you have to talk about it. But consulting about something is definitely a higher level, a higher requirement really between the parties, rather than just having a chat about it in a meeting. So very much watch this space, but I think this is really empowering employees to choose where, how, when they want to do their work, and the government is very much supporting individuals because of the home environments. I mean, we've just heard about the carers bill going through as well. So this is really giving a lot of flexibility to those employees who need it. So watch this space. The second thing. The second bill on this slide is the Worker Protection Bill. Now, this is also in the House of Lords at the moment, but there has been more pushback on this bill, I think, than the other ones that I'm talking about this morning. Now, the Worker Protection Bill creates a liability for employers to be liable for harassment by third parties. So third parties might be customers, clients, suppliers, anybody coming in, contractors. And if those third parties harass your staff, then you could be liable for not putting in place the measures that could have prevented that harassment in the first place. Now, the reason that this bill's had quite a lot of pushback is because of the onus and the extra responsibility this is potentially going to have to put on employers who can't necessarily control Joe Blogg's general public or any suppliers or customers and things coming on your site. And if you imagine scenarios, for example, like the NHS, where you've got so many patients and members of the public going through buildings, going through the system and interacting with employees on a day-to-day basis, it's going to be very, very difficult for some employers to put those controls in place effectively. So the types of things that employers are going to have are absolutely clear policies and procedures, which we recommend that you have anyway, because we're already in the place of potentially being liable for harassment between colleagues and between staff. So you should already have clear policies and procedures in place, which you train your own staff on. But this is making those policies and procedures clear to the outside world and to other people who may come onto your site and interact with your staff. So there's probably going to be an elevated requirement to carry out risk assessments. So if you are putting your employees and potentially, trying to work out who are your most vulnerable staff within there, and then do those risk assessments so that if they're interfacing or interacting with any third parties, you know what the risks could be of those interactions. And also updating things like your websites, notices that are around your sites, so that customers and people coming onto your site are very, very clear that you have a zero tolerance policy in relation to any harassment. So they're the kind of steps that employers are likely going to have to put in place in the future. But we'll see how this bill progresses through Parliament. I do think it will come in some form, but we'll have to wait and see kind of the level of responsibility and liability that's placed on employers once it makes its way back to the Commons. Okay, next slide, please, Catherine. Right, the next bill I'm talking about is the neonates bill. This is a new right which is going to give up to 12 weeks paid leave for parents and babies requiring neonatal care. This is also in the House of Lords at the moment. There doesn't seem any reason why this shouldn't go through as it is, but we do, before it will come into effect, some regulations will have to be drafted, and as far as I know, they haven't been started yet. So this leave, as we said, gives 12 weeks paid leave. Now that paid leave is at a statutory rate of pay, which is likely to be very similar to, say, statutory maternity, adoption, shared parental leave pay. It's available from the first day of work. So the leave itself is available if somebody has, you know, from the day one right, but the pay will only kick in once somebody has got the 26 weeks service and pay with their current employer, and they've been paying their national insurance through that time, and then they meet the minimum level of pay to get the statutory rates of pay. Now, this right is available to parents of babies who are admitted to the neonate unit, and those babies are under 28 days old and end up staying in the neonate unit for 7 or more full days. Now, the leave doesn't have to be taken at that time. What is more likely to happen, especially if you've got a mum who's given birth to a premature baby, is that the maternity leave will kick in as soon as that baby is born, but the neonate leave can be taken up to 68 weeks after the baby is born, and that leave is likely to be tagged on to the end of the maternity leave. So they're still getting the extra leave for having to be kind of in the neonate unit and having that stay in hospital, but it's likely to be tagged on to the end. And the same for any father or adopter of a neonate. They will be able to take that leave at a time of their choosing within the first 68 weeks of the child's life. So as we said, we're waiting for the regs to be drafted on that, and that will give us more information, but it does look like that will come in. And next slide, please. So the last on the horizon slide is the Predictable Terms and Conditions Bill. Now, this is something that was proposed as a result of the Good Work Plan that I think was came out in 2019, so it was a number of years ago now, and this is likely to have effect in probably in early 2024 that this comes in. Now, again, we're in the situation where we are waiting for regulations to be written to give us a bit more information about how this will work, but it's basically going to give a right to workers and agency workers where they have an unpredictable work pattern to request more predictability. Now, it is a request and it's not a guarantee that they're going to get that, but this enables those people to say, can I have a more predictable work pattern, for example, A, B, or C? They can make 2 applications within a 12-month period, and employers can absolutely reject that request, and there are statutory grounds on which they can reject the request, which are very similar to the grounds on which you can reject flexible working requests. So I think especially if you've got staff who are on very unpredictable shifts or work patterns or shifts that change all the time, or lots of maybe 0 hours contract workers or 0 hours employees, you may see those requests coming in. You will have to comply with certain timetables and dealing with them and responding to them, but you won't necessarily have to approve them all. We'll have to wait and see what the regulations say in terms of the level of whether there have to be a meeting, for example, or whether you can reject it without having a meeting, and the level of information you have to give back once or if you give a rejection. So again, watch this space and we'll see what happens when the regulations come out. Next slide, please. Right, moving on to the case law update. I'm going to kick off with the first case. Thank you, Catherine. So the first case is something that I've been doing quite a lot of work on, actually. It's a holiday pay case, which has been through the courts in Northern Ireland and is now at the UK Supreme Court. Now, this is the case of the Police Service of Northern Ireland against Mr. Agnew, and Mr. Agnew is joined by many, many other claimants in this case. Now, just in terms of a little bit of history about holiday pay, there's been a raft of holiday pay cases over the, let's say, last 10 years, and those holiday pay cases have covered things like, should we include overtime in holiday pay? Should we include voluntary overtime, compulsory overtime? Should we include commissions or other payments that employees get? And also, how much of an employee's holiday pay should be paid, taking into account all of those things? Now, in 2014, there was the case of Bear Scotland, and Bear Scotland set some principles which are currently applied in the UK. And those principles say that normal remuneration, so that's remuneration taking into account any, say, compulsory and voluntary overtime that the employee works, any commissions that they earn, all of that has to be averaged out, and that becomes an employee's normal remuneration. And you have to pay normal remuneration for the first 20 days of an employee's holiday. So employees get 20 days holiday under the European Working Time Directive. They get a further 8 days holiday under our UK Working Time regulations. And then some staff on top of that will get extra contractual leave. So some people might get under their contract 28 days plus the bank holidays. And those extra days then are counted to be contractual leave. But in the UK, everybody is entitled to 28 days. But the difference is that the first 20 days come from the Working Time Directive, which is the European legislation. And that is the proportion which has to be paid according to normal remuneration. So taking into account the overtime and the commissions and things. Now, in the UK, we also have a 2-year backstop. And that 2-year backstop says that even if you pay holiday pay incorrectly, in the UK, employees cannot claim more than 2 years back. But in Northern Ireland, they don't have that backstop. So if holiday pay is paid incorrectly and the employee is still employed and we still have a series of deductions going back over a period of time, they can claim back right back to the beginning of when those deductions started being made. So in Northern Ireland, it has been a more significant problem than it has in the UK. Now, the case that's come through at the Northern Irish courts went to the Northern Irish Court of Appeal, and I'll tell you what the outcome of that is at the moment, and that's the law in Northern Ireland. But the reason that it's important is that it's now in the UK Supreme Court, because once the case has gone all the way up to the Court of Appeal in Northern Ireland, it can't go any higher than that in Northern Ireland, and it comes to the UK Supreme Court. And the UK Supreme Court make the decision, and that impacts on everybody in the UK and Northern Ireland. So there's 2 main things we need to take away from this decision, and we are waiting for it at the moment. And I am watching the website on a weekly basis to see when the decision will be published. It was heard by the Supreme Court in December, and it should come out any day. So the 2 things to be aware of is that the Northern Irish Court said we shouldn't be treating holiday differently. So whether it's the 20 days under the Working Time Directive, the extra 8 days that we get in the UK under the UK regs, or contractual leave, all holidays should be treated the same, and it should all be paid at the level of normal remuneration. So taking into account overtime, holiday pay, etc. So that's the first thing to be aware of. And the second thing to be aware of is that the Bear Scotland case in 2014 found that if there'd been a series of unlawful deductions, so a series of underpayments of holiday pay, but there was a period where the employer paid it correctly for 3 months, that would break the chain, and the employee couldn't then claim the unpaid holiday pay from behind that 3-month period. Now, the Northern Irish courts have said, no, we're not having that. There shouldn't be a 3-month break. Even if there's been a 3-month period where holiday pay has been paid correctly, the employee should still be able to claim for the more historic payments as well. Now, it is expected that the Supreme Court will agree with the Northern Irish courts on these 2 points. So the reason it's quite important is that a lot of employers, because of the cost of paying holiday pay to include commissions and overtime and everything else, a lot of employers do only apply it to the first 20 days of leave. And if you are one of those employers that is doing that, you really do need to keep an eye on this case, because if this case comes in and overturns that, which we expect it might do, then you will have to make sure from that point that you are paying holiday pay correctly for the employee's full contractual leave, whatever that might be. So hopefully we can bring you more news about that case in the next one, but it is certainly one to watch out for if holiday pay has been an issue for you. Next case, please, Catherine. Right, moving on to, I've got 2 cases now on redundancies and reasonable adjustments. Now, redundancies have definitely been, and restructures have definitely been a trend that we've seen a lot of recently. I seem to be jumping from one large restructure project to another at the moment, and I think many employers, again, post-pandemic, are really looking at changing their business around and potentially making efficiencies in the business to make everything more profitable. So the first case of Mr. Hilaire and Luton Borough Council involved Mr. Hilaire, who suffered from depression and arthritis. Now, he had been off sick throughout the whole of this restructure process, and his employer went about this restructure, and they decided that if any employees wanted a role in the new structure, they would have to apply and interview for those roles. And that was how they were going to select who would be successful in the new structure. So they invited applications from everybody, and then they interviewed those people who wanted the jobs. So Mr. Hilaire wasn't treated any differently to anybody else in the process. And again, even despite the fact that he had these conditions, he had to go through the same process as everybody else. However, he wasn't happy with the way he'd been treated in his sick leave, and he refused to attend the interview. And as a result of that, he wasn't offered a job in the new structure and was made redundant, so dismissed by reason of redundancy. Now, he then brought a claim and said that the employer, Luton Borough Council, had failed to make reasonable adjustments, and he said they should have made reasonable adjustments. And he argued that a reasonable adjustment in this situation would have been to give him one of the roles in the new structure without any interview or application process. They should simply have slotted them in. Now, this case went all the way up to the EAT, and this was good news for Luton Borough Council and good news really for employers. The EAT said that slotting him into a role without any interview would not have been a reasonable adjustment, and it would actually have impacted detrimentally against the other people who were also waiting. I think there were 13 people who'd also applied for this same job, and they were waiting for an outcome. So it would have impacted them detrimentally to simply slot him into the role. Now, the EAT looked at the adjustments that Luton Borough Council had made, and they said they had actually made some adjustments. They'd given Mr. Hilaire more time to attend. So when he said, I can't attend because I'm not very well, they actually delayed the interview process. They made everybody else wait a little bit longer to try and find out the outcome, but he still didn't turn up. But the nail in the coffin really for Mr. Hilaire in this situation was that he'd actually sent an email to his employer at some stage saying, even if I wasn't off sick, I still would not have attended this interview because I am not happy with the way that you treated me whilst I've been off sick. So the EAT actually found that the real reason for his non-attendance at interview was because he had lost faith in his employer, and he was trying to use that as a backdoor way really to bring a claim for unfair dismissal. Now, the key learnings really from this claim are that if you've got an employee who is disabled and you're going through a redundancy process, then you must consider what reasonable adjustments you should be making for that employee as you go through any selection or scoring process, and whether you should be doing anything. If you're not sure, it's always a good idea to seek advice, whether it's from us or occupational health in the first instance. Now, the other thing that the tribunal said here is that if you are making a reasonable adjustment, it has to actually either alleviate the disadvantage that the individual is suffering or remove it completely. So you've either got to reduce the disadvantage or remove it completely by the reasonable adjustment. If the reasonable adjustment doesn't do either of those things, it doesn't reduce the disadvantage and it doesn't take it away completely, it is not a reasonable adjustment in legal terms. Okay, so if you are thinking to implement any reasonable adjustments, you do really need to be thinking about, is it doing one of those two things? One of the points to mention here is that reasonable adjustments as well are to help people either back to or in their job. So one of the questions we frequently get asked is, the individual who's on sick leave wants us to extend their company sick pay. Is that a reasonable adjustment? And no, that will never be a reasonable adjustment to extend company sick pay, because you're actually encouraging somebody to stay off sick even longer. So the whole idea of the reasonable adjustment is that we get people back to work and we help them in their job. Okay. Next slide, please, Catherine. So our next case involves the household name of M&S, and it involves a lady called Mrs. Jandu. Now, Mrs. Jandu had worked for M&S for 22 years, and she had dyslexia. She had been put through a redundancy process and was made redundant at the end of that process. Now, she only lost out by 1 point. And the selection criteria that M&S had applied throughout the redundancy process, they looked at leadership skills, technical skills, and behaviours. And they scored all of the employees in the pool on those 3 categories. Now, the managers were totally aware of Mrs. Jandu's dyslexia, and she had made it known through her career the assistance that she needed, and people generally had been very good at helping her with those things. They proofread important emails for her, they color coded certain things so that she was aware of importance and things like that. And at no point were any performance issues raised with her about the things that she was scored negatively on. So M&S had not referred Mrs. Jandu at any point to occupational health. And as part of the redundancy selection process, when she was told about her scores and the scores against these 3 specific selection criteria, she raised her dyslexia as a reason for these issues. And M&S's response was that we are not here to talk about your dyslexia, and they brushed it away. Now, the issues which were raised and which impacted negatively on her scores were that they felt her emails were rushed. They tended to be very brief, often set out in bullet points rather than kind of a more verbatim tone. There were many spelling errors. They also raised issues with her time management and a failure to adapt the tone of her written communications to different audiences. Now, the tribunal found that all of these issues could be attributed to her dyslexia, and M&S should not have brushed that aside and should actually have taken that into account and thought about whether they should make any reasonable adjustments, for those issues, given their knowledge of her dyslexia. Now, the other thing that M&S did wrong here is that they used those things to mark her down on every single one of the scoring criteria. So when they looked at her leadership skills, they took into account the poor email writing and the time management and the spelling errors in relation to leadership. Then they went on to technical skills and they took the same things into account in relation to her technical skills. And then they went on to her behaviours and took the same things into account. So she was actually scored down for the same reason 3 times. And if she hadn't done that, then she would absolutely have scored those extra 1 or 2 points, which would have saved her in the redundancy process. So M&S are obviously a kind of very household name, a big retail giant, and the tribunal found that M&S absolutely had the resources to make the reasonable adjustments which they should have done for Mrs. Jandu. So the learnings coming out of this case, and there's several really. Firstly, if you have any employees with performance issues, do raise them quickly and early doors, and then hopefully, firstly, you can nip them in the bud and maybe put things right to start with. But it does mean that if you find yourself in a redundancy process with an employee and you've already raised performance issues, you will have documentary evidence of those and you'll be able to rely on it and use it in the scoring process. Secondly, and what one touching on from the Hilaire case that we've just talked about, if an employee does have a disability and is being put through a redundancy process, you really need to be considering about, do we need to make any adjustments as part of this redundancy selection or scoring process because of this employee's condition, and get advice on that if you need to. Things you might need to make, for example, are giving them more time, giving them breaks if there's an interview, maybe they need regular breaks, maybe questions need phrasing slightly differently. It obviously depends on the disability, but you certainly need to take account and think about what adjustments need making, and make a note of it as well, so that you've got evidence that you've gone through that process and you can show you've done it. And then just some general guidance that if you are going through a redundancy process, you really do need to be using objective scoring criteria and not subjective criteria. One of the biggest downfalls I think that we see in redundancy processes is people often want to score on very subjective criteria, and especially if you've got a large scale redundancy and you're, say, scoring on, let's say, communication style or communication skills. It's a very soft skill, and it's very subjective then for that person's manager to be saying, yeah, I think they're a good communicator or a bad communicator, and it's very unlikely that you've got hard documentary evidence to back that up. So you're much better choosing objective scoring criteria and criteria that you can back it up with documentary evidence. You also need very clear scoring guidance. So say you're scoring out of 5, what do you need to get 5? What do you need to get 4, 3, and 2? And be very, very specific about the points that somebody needs to achieve to get those different scores. And especially that helps if you've got a lot of managers who are involved in the scoring process, so that there's consistency across the managers as to how they're approaching that scoring criteria. Okay, next slide, please. Right, this is the last one from me, and this is a disability discrimination case, and a case involving long-term sickness and dismissal. Now, in this case, Revenue and Customs did everything right, and this case really gives some useful commentary from the Employment Tribunal if you're going to launch a defence against a disability discrimination claim. So just a few facts. Mr. McAllister suffered from anxiety and depression. Now, this case is quite fact specific in terms of his level of absence. Now, he had 245 days absence in 2 years. A really, really high level of absence. And at the time of dismissal, he'd been off sick for 7 months, and occupational health, he'd been referred to occupational health. As I said, they did everything right. And occupational health had said he's not fit to return in any capacity at this time. So he, Revenue and Customs said that his absence was having a really detrimental impact on productivity and staff morale. They tried to make all the reasonable adjustments that had been suggested, but obviously he wasn't fit to return in any capacity, so they decided to terminate on the grounds of capability. And Mr. McAllister brought a claim for discrimination arising from his disability. Now, the reason he brings that claim is because he was actually dismissed for his level of absence and not the disability itself. So because he'd been dismissed for the level of absence, he brings the discrimination arising from a disability claim. And it is possible for an employer to defend that claim if they can what's called objectively justify their decision to dismiss. Now, the objective justification defence has got 2 strands to it. The first strand is that an employer must have a legitimate aim that it is seeking to achieve. And then the second strand to the aim is that, was there a more proportionate way that they could have achieved that aim? In other words, they've got this aim they're trying to achieve. Could they have done it in a less discriminatory way that didn't discriminate against the particular claimant? And in this case, the tribunal looked at all the facts and they said, no, Revenue and Customs did do everything right. They couldn't have achieved these legitimate aims in a less discriminatory way. And they found in favour of Revenue and Customs. Now, the reason this case is useful for employers is because 3 legitimate aims were put forward by Revenue and Customs here. And I think these are really wide aims and helpful for employers. So they said, our legitimate aims are ensuring that staff demonstrate a good level and good standard of attendance. That was number 1. Number 2 is that we want to ensure that we give our our customers a good customer service. So that was number 2. And their third legitimate aim was the need to follow their own policies and procedures for consistency purposes. That was, after all, the reason that you've got policies and procedures in the first place. So That's really useful because there's been very little guidance in the past on the type of legitimate aims that employers could rely on in this situation. And these are very broad aims. So the second question then was, could they have achieved those aims in a less discriminatory way? And that will obviously depend on the facts of the case. But in this case, Mr. McAllister got such a high level of absence that there was no doubt really that it was impacting on morale. Now, the one piece of advice I would generally give, if you've got an employee who has been off sick for a very, very long time, before you dismiss, you always need to refer to occupational health. And if somebody said, oh, we did an occupational health referral 4 months ago, I would say you need another one. You need an up-to-date one, especially if there's been recent changes and they've been off sick. You don't know what's happened in the meantime from a medical perspective. So you need an up-to-date medical health, occupational health report before you go through the dismissal process. And if you get to that point, ideally, you're looking for occupational health to say they're not fit to return in any capacity, and ideally for several months going forward. If occupational health were turning around saying, actually, they're not fit to return in any capacity at the moment, but give it 3 or 4 weeks and I think they'll be back, then no, you should, that's too soon. You shouldn't be dismissing. But if you've got a much more longer term kind of prospect of them staying off and not fit to return in any work, then you're going to be, in a much better position to proceed with a capability process. The capability dismissal should always be the last resort, and you should be looking around for other options first. Right, I think it's back to Stuart now. Thank you, that's mine.
Okay, back to me for the last 4 cases. So first case is the McGain case, and it's a word of caution for anyone out there who thinks that making employees redundant is overly simple. And when I make that comment, I try and frame it in the right way. And as much as I'm quite happy to accept the fact that over the years I have said on more than one occasion to clients that dismissing an employee on the grounds of redundancy is arguably the easiest way of effecting a fair dismissal, particularly when you're looking at a pool of 1. But it doesn't mean to say it's really easy, and it doesn't mean to say that there is no risk associated with that. And this is a really useful case for employers. It's a word of caution that these are not overly simple, and it highlights still the need for appropriate consultation. So in order to bring this to life, as with all these cases, it's good to provide you with the facts. So Mrs. M was employed by the trust as a band 6 nurse under a series of fixed term contracts. There was another band 6 nurse who was also employed under fixed term contracts, but Mrs. M's contract was the one that was going to come to an end first. In March 2019, she was invited to a meeting and she was told that the trust was facing some financial difficulties, and a short time after that, the trust decided to basically make her redundant because her contract was ending at the soonest. Now, in making that decision, I want to stress that the trust didn't just make that decision with click of fingers. They still went through a redundancy consultation process, but they very much concentrated. They chose her because of the fact that her contract was coming to the end sooner than the other band 6 nurse, and they then complied fully with complying with their duties of considering her for suitable alternative employment. She went to the employment tribunal and they rejected her claim, finding that she'd been fairly selected for redundancy. What then happened is that she appealed that case. We went to the employment appeal tribunal, and the employment appeal tribunal made reference to some of the, I suppose, the seminal cases in the context of redundancy, and basically reminded or both the parties that consultation is a fundamental aspect of any fair redundancy process, whether or not you're looking at small scale redundancies or whether or not you're looking at redundancies that trigger the duty to collectively consult. And what we always say, and this is enshrined in case law, is that consultation needs to be genuine and meaningful, and it must take place at a time when either, if you're consulting with individuals, the employee can influence the outcome, or if you're consulting with employee reps, that the employee reps can influence the outcome of that process. So the key point here is, in the context of this case, the choice of the selection criteria had the practical result of basically selecting the person to be made redundant from the outset. And they said, well, actually, that didn't then amount to meaningful consultation, because consultation should take place prior to that decision to be taken. So in this case, what they should have done is they should have consulted about whether or not it was appropriate to use the fact that the contracts were ending soonest as being the selection criteria. What the AT went on to say is that whilst a pool of one can be fair in appropriate circumstances, it should not be considered without prior consultation where there is more than one employee. So this had an adverse negative impact on Mrs. M, and she was successful from the AT is concerned. So, in this case, the trust had gone to great lengths with regards to complying with its duty to consider for suitable alternative employment, but that wasn't enough. So the word of caution is to make sure that you don't, I suppose, overly simplify redundancy consultation processes, even when you think that you're looking at a very small pool. Always make sure that the process that you're following builds in appropriate consultation, whatever that might mean, and to make sure that you tick the fact that the process is a meaningful one. Okay, and I suppose the good news is, just picking up on Charlotte's point, is that there was lots of debate last year, wasn't there, about that being the year of the Great Resignation and whether or not 2023 was going to be the year of the Great Redundancy. I just think at this point probably share with everyone that whilst we're seeing pockets of redundancies and projects, we're not seeing absolute mass redundancies at the moment. Whether or not there's more to come down the line, we're not sure, but that's certainly what's landing on the desks of us up and down the country. Okay, next one, from redundancies to settlement agreements. The case of Bathgate looked at how far a settlement agreement can go with regards to settling unknown claims. For those of you who deal with settlement agreements regularly will know there's much debate about how far a settlement agreement can go, and a case back in 2004 summarised two key principles. One is that blanket settlement agreements are unlawful. That said, despite the fact that the general position is that blanket agreements are prohibited, an agreement that identifies an actual or potential claim by way of general description or reference to the section in the legislation that gives rise to can still validly settle that claim. So a good settlement agreement, he says in a slightly cheesy comment, like all the ones that we draft here at Shoosmiths, will be tailored to the individual circumstances that you are facing in the main. We will not include any claims that definitely have no relevance. We include tailored wording, and then we include additional wording to make sure we try and catch all those other claims that might apply, but we won't adopt the kitchen sink approach that some lawyers do. The second principle is that whilst parties may agree that a settlement agreement is to cover future claims in respect of which an employee does not or could not have knowledge of, to do so effectively, the terms of the agreement must be plain and unequivocal. And our advice when we're talking to clients about this is to always make sure that they've got awareness that there is some uncertainty about the enforceability of settlement agreements that seek to settle claims that aren't, I suppose, automatically in the minds of the employees or haven't yet arisen. So this case looked at, I suppose, the second limb, the second main principle there, and the facts are on the slide, but I'll run through them quickly. So Mr. B took voluntary redundancy under a settlement agreement, which included a term for a future payment under a collective agreement. Unknown to Mr. B, when he signed up to the settlement agreement under the terms of the collective agreement, no payments could be made for anyone who was aged over the age of 61, and as a result, he didn't get any of the monies that he was expecting. Unsurprisingly, he brought a claim for age discrimination, and rather unsurprisingly from the company perspective, they sought to rely on the terms of the settlement agreement. Again, this was another case that ended up at the AT, and the AT concluded that the statutory requirement for a qualifying settlement agreement to relate to a particular complaint requires an actual complaint to exist or circumstances where the grounds for a complaint to exist as well at the time. So the general view being is that it comes down to what was known at the time that the settlement agreement was entered into. So the context of this case If it was known, if Mr. B knew at the time of the fact that he wasn't going to have a potential entitlement to this additional monies, then it could have validly settled that claim. But because it wasn't in his awareness at that time, the settlement agreement couldn't validly be used, and therefore the company didn't have the protection of the settlement agreement. So how's that impacted on the advice that we're giving our clients? It shifted it ever so slightly, but not in any major form. We still flag to clients the uncertainty in relation to the possibility of settling future claims, but what we do make sure is that we do, I suppose, extrapolate when we're taking instructions. We ask very, very clear questions in relation to what issues could have arisen or potentially could have arisen during employment that could give rise to claims, to enable us to, I suppose, word our settlement agreements as bespoke as possible. Okay, next slide, please. The penultimate slide for me actually relates to a set of circumstances that are very similar to a case that I advised on recently, and it looks at what happens to the employment relationship where an employee appeals a decision to dismiss. The employer then offers reinstatement, but then the employee doesn't want to return to work. I don't know if you've ever faced situations like that, but it is something that does, as I say, land on our desks reasonably frequently. So before telling you what the outcome of this case was, let's look at the facts again. So the claimant in this case was dismissed for gross misconduct in January 2019. She appealed the decision and she indicated that she wished to be reinstated. But then she changed her mind and she sought to argue that there'd been a breakdown in mutual trust and confidence between the parties. And at the appeal, she said, all I want is an apology and I want some compensation. Isn't it the case, often the case, that just employees want its compensation? But whether or not it was a tactical decision or not, the outcome of the appeal for Iceland was that they basically reinstated her, but she basically refused to come back to work. And she was dismissed again in July 2019 for failing to return to work. And she brought a claim for unfair dismissal, and she sought to rely on the dismissal, not in the July, but she sought to rely on the dismissal that had taken place in the January. And the tribunal in the first instance concluded that it had no jurisdiction to hear the claim, as the January dismissal had basically vanished as a result of her reinstatement. And she appealed that decision, and it's always good that we go to the AT because that gives us better authority. And I'm pleased to say, he says, you can tell that I've got a slight slant, haven't you, towards employers, but the AT agreed with the tribunal's decision. And they said that basically it's clear that the outcome of the successful appeal in a situation like that was to treat the dismissal as if it not having occurred, irrespective of the employee's subjective wishes. So one thing what the claimant could have done in a situation like this, if I was advising the claimant, I would have advised her to have withdrawn the appeal. Now that might have impacted on the amount of compensation she could have claimed before the tribunal, but she would have then only have had one dismissal to rely on rather than, I suppose, the two. The second thing which isn't really talked about as far as the case is concerned is that limited her from bringing a claim in relation to the January dismissal. She could potentially, I suppose, have also sought to bring a claim of constructive unfair dismissal if she could have shown it wasn't reasonable for her to have returned back in July, but that's beyond the summary here. So, and then last but not least is the case of Lifecycle, which is, again, another really interesting case, probably one that's may not land, but it raises some really interesting questions. And it looked at basically, I suppose, the question of whether or not the double jeopardy rule applies in the context of employment proceedings. So the double jeopardy rule usually arises in the context of common law cases, where basically it says that you can't litigate the same issue twice. Most people probably heard about this, depends on how old you are. I'm going to show my age a little bit here, but the very, very famous Stephen Lawrence proceedings, that was one that got a lot of press, and I suppose probably quite a lot of frustrations from the public perspective about the fact that people couldn't be tried for the same offence. But the headline comment of this case was the Court of Appeal held that there was no absolute rule against double jeopardy in the world of employment. and this was in the context of an unfair dismissal claim where an employee had already been taken through a disciplinary process that hadn't resulted in a dismissal in the first instance. So to explain the unusual circumstances, I'll go into the facts. So in this case, the claimant was a director of transformation at the NHS Trust who had responsibility for improving race and equality, and she was the chair of their BME network. She was disciplined and given a final written warning for instance of bullying and victimisation an employee by seeking to interfere in an investigation of sexual orientation discrimination, racial harassment and discrimination against another employee. You have to pause at that moment, don't you, and think, actually, why did she only get a final written warning? But anyway, she was only given a final written warning in the first instance. What happened then was that the Care Quality Commission, the CQC, you may have heard about them, but they carried out an inspection and they concluded that bullying was rife within the trust, and they put it into something called special measures. And what happens when special measures takes place is that then the trust gets taken over by another trust, and the managing director of the new trust basically came in, and he was so concerned about I suppose compliance from a regulatory perspective. He was concerned that whether or not the claimant was fit and proper to provide leadership on issues in relation to equality, and that then triggered a further disciplinary hearing that was held by the new trust CEO, and that resulted in her dismissal on the grounds that her conduct had fatally undermined her ability to perform her leadership role. One of the arguments that the claimant then pursued at the AT was the fact that it was unfair for basically her to be subject to a disciplinary hearing that had also to a disciplinary matter, that had already been considered as part of the original disciplinary process that had resulted in her getting a final written warning. And basically the AT said, as I said, endorsed by the Court of Appeal, was the fact that actually there was nothing to prevent this issue to be considered again. They said that what had happened in relation to the earlier disciplinary hearing was just one part of the circumstances that an employer can take into account. The court though did take into account other factors, and that was the findings of the CQC report, the claimant's continued unwillingness to accept any responsibility, and the CEO's conclusion that the claimant was basically unfit to lead on issues such as race equality in light of her conduct. So what are the lessons of this case? I suppose the lessons of this case are that it's good news from an employer perspective that potentially you can revisit issues like this. I think the facts will be I think it would be pretty unusual that these sort of facts will arise for you. I suppose there is one similar set of circumstances that I did want to highlight, and that was just to remind everybody whether or not if you go through a disciplinary process and an individual appeals that decision, whether or not you can actually increase the sanction as part of that disciplinary process. And I just want to highlight the fact that there is authority for the fact that you can't do that. The reason why, and that was a case of Macmillan, and that was the reason for that is that the appeal process is there to benefit the employee, not the employer. And also the fact that if you appeal something and then you get given a more tougher sanction, you've got no further right of appeal. And also ACAS is pretty clear as to what their view is in relation to that. If you do want to have the ability to increase a sanction as a result of appeal, then you can have that within your contractual procedures, but please do make sure that you make it clear that if that's the outcome of your disciplinary process, that the employee's got a further right of appeal. So whilst I imagine that the facts of the case Lifecycle are pretty unusual, there are some similar cases that are hopefully useful takeaways for the purposes of today. So that's it, 12:08. We left some time for some questions. I'm going to pass over to Antonia to see if there's anything's been asked that we need to pick up on.
Yes, so I don't suppose it's going to surprise you that we've had a question about holiday pay, because that seems to be the thing that causes the most headaches. So I think the way the question is phrased, so it's looking at overtime and what overtime you include in holiday pay calculations. So this particular question has looked at ad hoc overtime for 0 hours workers. And my understanding is that if it's genuinely ad hoc and isn't something that you get regularly, then it it's not part of your normal remuneration and therefore isn't included. But where the dividing line is between ad hoc payments and then becoming regular enough to be included is kind of the million-dollar question. Would you agree with that?
Absolutely, absolutely. I think there's the massive question on when it becomes regular, and each scenario will be different. I mean, I had one a couple of weeks ago where they said, oh, yeah, they're just doing overtime, you know, maybe like once a month or something. And I said, well, once a month for how many months? You know, because once we get into once a month for 2 months or 3 months, that's regular. So, you know, it's really looking at the timeline, like you say, and working out, is it truly ad hoc? Are we saying kind of once here and then 7 months later, another one here? Or is there any kind of sequence really in what's happening?
Yeah, and I'd simply endorse that. It's that, and then there's no legal definition. Well, it's only those situations where it is genuinely ad hoc that it doesn't need to be taken into account. So it's about reviewing patterns at the end of the day. Really, really tricky area to advise on, but yeah.
And I think if there's any discrepancy, a tribunal is more likely to come down on the employee side. So if it's like, okay, well, we might be seeing a pattern, but we might not, you know, and you're kind of at the 50-50 on the fence side, then the tribunal is possible, you know, I think they'd be more likely to come down on the employee side.
Cool. So yeah, we're having some more questions coming in thick and fast now, actually. What I guess this is another one that we come across quite a lot. So what happens, I think, so you were talking in the cases, particularly Charlotte, around the need to engage with occupational health and to understand the up-to-date medical position. But what happens if the employee refuses to engage with occupational health? And I think, in my experience, as long as the employer has attempted to get that up-to-date evidence and has made it clear to the employee that if they won't cooperate, the employer has to make a decision based on the evidence that they've got, that ultimately that's all you can do. You can't force somebody to cooperate with you.
No, absolutely. And I had a case that went to tribunal that was just that, you know, and the company tried to refer them to occupational health and actually asked on several occasions and had documentary evidence of the fact that they'd done that and the employee's refusal. And it went all the way to tribunal, and the tribunal said, you know, the company has done what it could, you know, what it should have done. It's complied with all its obligations, and the fact that the employee has refused to go means that the company can only make a decision on the evidence available. And the evidence available didn't include the medical information. So they absolutely came down on the company's side there.
Yeah.
And if you've got anything in the contract that you can point to, or your sickness management procedures or whatever, that, you know, you can't never force anybody to be subjected to a medical, but if you've got something that says actually we've got a contractual right, then that can strengthen your position as well.
Yeah. Cool. And then perhaps just one quick clarification. So on the extending redundancy protection, are we saying that employees on maternity leave should have priority over other employees? And yeah, essentially that's what happens if there is a redundancy situation. One of the people who's selected for redundancy is on maternity leave. They have the right to be given a suitable alternative employment if that exists.
Yeah.
Above
So
others.
You've got different tiers of prioritization, haven't you, in a redundancy situation? So let's say, for example, we're going through a redundancy situation that puts 2 people at risk of redundancy and you've got 1 vacancy. If there are 2 employees who are not, when they need them off on maternity leave, then they will have priority over your other employees, or in fact over external candidates. If they're suitable for that role, they should be offered it. That's something that causes a lot of frustration for employers, but it's all about protecting employment for employees and, you know, right not to be unfairly dismissed. If one of those employees is within the protected period and they're both suitable, she gets the role. It's you know, even if the other person is more suitable than her, she has that much extra. It's gold plated protection.
Great. So I'm conscious we're just coming up to 1:15. So we've had a few more questions, but it might be we can have a look through those and come back to people separately after the event, rather than I know, Stuart, you said you were a stickler for time.
Yeah, thanks, Antonia. Okay.
Yeah,
Jackie,
thank you,
I think
Antonia.
come on.
We've tried to squeeze in as many of your questions as possible, but once we open up the Q&A, they do tend to come in thick and fast. But I'll get those across to the Shoosmith team afterwards, and we'll try to compile some answers and make those available to you, either individually or just sort of as like a combined document. So leave that with us. We've got them all noted down. I can see lots still coming in. Thank you to everyone who joined us today and made it all the way through to the end. You've done it. You've completed today's employment law webinar. Well done. We hope you found it really helpful and you've enjoyed the insight not only into Cipher solutions from Jackie, but also all the explanation of upcoming legislation, case law, and this little Q&A from Shoosmiths team. If you want more information either about Cipher or from the team at Shoosmiths, there'll be an exit survey at the end of this broadcast. Just check the relevant box and we'll get back to you. And that survey also asks you for some feedback about the webinar today and if there's anything you'd like to see from us, particularly on employment law matters in the future. Do take a time to fill that in if you can, because it really helps us plan our future programme of webinars. And just as a reminder, all this has been recorded and the recording will be emailed to you. So that will be all the audio explanation and the slides, so you can rewatch that and revisit it at your leisure. So you can just revisit any bits that you might need extra clarification on. So thank you, Jackie, for joining us today. Thank you, Antonia, Stuart and Charlotte, for sharing your expertise. I really appreciate you joining us today. It's been great. Thank you so much, everyone, for joining us and being so attentive and engaged. We really appreciate it. And we hope to see you again at another Cipher webinar soon. Take care and have a great day. Thanks again.
Bye-bye.
Thank you. Cheers. Bye.